Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dahil mihi Anglican po, he's very much about it.
That's literally not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, for Trump's sake.
All right, good afternoon. Welcome to the Court of Public Opinion. I am the Recovery Addict. Merry Christmas, you filthy animal. No, that's keep your change, you filthy animal. I'm mixing up my quotes. A Merry Christmas to y'all. It's great to have you here. Welcome to Christmas week. Oh, man. Oh, bum, 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 bum. Ashley Buzzard has been arrested in connection with Melody Buzzard's disappearance per ABC News. Just add one more watch list. One more to the watch list. Police are saying they should not cooperate. All right. So let's get everything back where it goes here really quickly. That goes there. I think I need a macro that will just fix everything. I think I need I'll have to set that up. Right, Merry, everybody. Yes, a Ramblin' Rome. I hear it. Bah humbug. Joyce, I hear you there as well. All right, welcome. Everyone grab your blankets and find a place on the circle rug by your rug. It's story time. There are a lot of documents. A lot. We're talking about trial 1 in Karen Read, where there were a lot of sidebars. And particularly, it's the sidebars. It's the sidebars that we're most interested in. So we are going to do a little bit of reading. I've got some water. I've got a stash ready to keep my voice fresh. And we have documents. We have all the documents. Seriously, need to know, just me trying to figure out chat. Welcome. Is everything working? The seats are working? Do we have sound effects yet? I don't know. Let's see. Should have sound effects. Hopefully. Now I'm going to check. Hang on. Let me do a quick test. Nope. Okay. Now we should. In theory.
Hello.
There. See, now it started working. All right. We're here. They released the sidebars. Yes, it's all going to be released by when they say release. There are lots of documents that have been released lately, and the black marker has been used liberally on some of them, if you know what I mean. Will you be live tomorrow? I will be alive tomorrow, and we will be live in the morning doing a special Christmas holiday edition Christmas tree show and tell, which you should participate in by sending a picture of your Christmas tree either to the burner phone or to the Facebook page. Not someone else's Christmas tree, not here's one I saw on Facebook, not here's my neighbor, they're really cool. Your Christmas tree for show and tell. And
Hello.
And we've already got quite a sizable presentation. All of them decorated better than mine, I might add. Well, no, I shouldn't say that too loudly. All of them looking more professionally decorated than my own. Regina Crawford, Christmas has me strapped. Share McDonald's breakfast on me. Merry Christmas, Regina. Thank you. Big Mac for Christmas. I'm all in. I'm all in. I like that. Thank you for your generosity. Merry Christmas, Regina. AI Christmas trees? No. Have you redacted the internet owner today? Greeners, congratulations. You're first in chat. We're going to punish you for your promptness. Everything IP related worldwide is your responsibility. You are, in fact, the internet owner, which you would think comes with some prestige. But no, it's a punishment. You only get to fix it and then give it to somebody else. You can't really do much more than that. Congratulations, Greeners. You've won before. You'll win again. Marissa, T3, member for 11 months. Welcome to the gallery. 11 months. Merry Christmas, everyone. Thanks for a wonderful year. Marissa, thank you. Thanks for making this year wonderful. My tree still sits naked in my living room. I'm glad you clarified.
Hello.
Since the day after Halloween, just can't get to it yet. That's awesome. Cindy Stovall. Sorry, I got that there. Tomorrow's my birthday and officially retired. That deserves
Scratch off.
Not that button. Excuse me. That deserves this one. That was loud. I'm sorry. Congratulations. We will sing it to you tomorrow. We're going to do the birthday song in the morning. Make sure you get on the list. Make sure you get on the list, Cindy. Put it on the form, and we'll get you sung too. The tree is up and decorated. Gifts are under the tree. Half a day work left before the holidays. I'm feeling very joyous. You should. You should. Good afternoon, Pixel fam. Good afternoon to you, Legally Blonde. How's the family doing? Thanks for the pictures, by the way. Liked it. Let's jump right in, shall we? Let's jump right in. Let's jump into back in the day. Let's see, back in the day. I forget. Who was this? Was this Jen McCabe on the stand? The beginning of the day? I think it was Jen McCabe. Amber and I talked a little bit about this one. We're just picking one out. We're not going to read the whole thing because we would be here for weeks reading these transcripts. Because it's the transcript of the whole trial. We'd be here forever. Francis Fitzgerald says, Recovery Addict, say hi to my hubby, Cowboy Fitzgerald. I sure will. Cowboy Fitzgerald, welcome. Thanks for letting Francis hang out with us. You guys are all welcome all the time. Appreciate it. Can't wait for these. I was hoping you'd read them. I have not pre-read them. I can tell you this. I have no idea what's coming. And I'm very curious what the conversation, how it went at Sidebahs. So I will do my best, and why not? Let's kick this off because, it's time, as they say. It's time. Morning start of cross-exam opens with spice. Okay, so here's what we have. Let's go to the top here. There we go. Can you all? Oh, you can't see that either. How about right here? Go to 7. You can see it on 7. Great. All right, we have. I need to be able to see it on the big screen. Focus. Here we go. All right, Commonwealth of Massachusetts, Norfolk Superior Court, Department of the Trial Court. It's our docket number before the Honorable Beverly Cannoni. Tuesday, May 21st, testimony of Jennifer McCabe is where we're picking up. Remind you of the players. We have Adam Lally and Laura McLaughlin. And then for the defendant, we have David Inetti, Alan Jackson, and Elizabeth Little. And then here's our court transcriber and reporter. Great work. We appreciate you doing this so we can all get this. So direct. I'm not sure what this number means. Witness direct by Mr. Jackson, 6. We have 2 exhibits, thumb drive with recording, a redacted document regarding Jen McCabe. Now we scroll down. The court is in session. Defendant is present with counsel. The clerk says, calls the case. 22-117, Commonwealth versus Karen Reed. Counsel, identify yourselves. Adam Lally. Says Adam Lally for the Commonwealth. Good morning, Your Honor. Good morning. Good morning, Mr. Lally. Miss McLaughlin says, good morning, Your Honor. Laura McLaughlin for the Commonwealth. Good morning, Miss McLaughlin. Mr. Jackson says, good morning, Your Honor. Alan Jackson for Mr. Reed. Good morning, Mr. Jackson. Miss Little, I'm sorry, I can't do Bev. I can't do it. Do all the voices. I can't. I need more Boston. Is it Boston or Boston? Elizabeth Little on behalf of Mr. Reed. Good morning, Ms. Little. Mr. Inetti said, good morning, Judge. David Inetti for Karen Reed. Good morning, Mr. Inetti. Good morning, Ms. Reed.
Just use your words.
Just use your words. So I was told you needed to see me. This is how every day started right here. Basically, sidebar. Mr. Inetti says, just briefly, the court says, before the jurors come out, Mr. Inetti, briefly, which means brace yourself. Mr. Inetti says, sidebar. This is the part we didn't get. And it would be funny. Oh, my goodness. It would be funny if we went and got the video. This would be hilarious. And if I could read along as we watch them at sidebar, but of course, we'd just be looking at the clock. Anyway, Mr. Inetti says, Your Honor, I want to present this delicately at this sidebar, given the nature of the topic here. We've let this go on go for about a month, and we feel the need to bring it to the court's attention that continually throughout this trial, the O'Keefe family and supporters who are directly facing the jury in this trial have been making faces, rolling their eyes, sighing, swearing audibly, and essentially giving input that the jury is readily able to see in light of the fact that we face them. The judge says, who specifically? Because I've been looking around the courtroom and I haven't seen it. So who specifically, if you can? Mr. Unity says, I think it's been multiple members. This is not sidebar. This happened in open court, I think. I think it's been multiple members. It's been most egregiously John's mother, Miss O'Keefe, and it's been caught on camera. We're not looking for them to be admonished publicly. In fact, just the opposite. Our request would be that a court officer address this issue with them, let them know that they cannot be giving their reactions, so they're giving in the light of the fact they're seeking a neutral jury. And their behavior is contrasted with that of the Reed family, which has given no reactions whatsoever. So that's our request. Mr. Elliott says, I don't know that I'd agree with that last part. Judge says, well, so you must have told Jim because he mentioned it to me. So I asked the court officers, and that's part of their job to watch. And they're saying that they're seeing a little bit from both sides, but it's nothing any greater than any other trial. And I will then ask the court officers to pay extra close attention to make sure there's none of it. Shinetti says, okay. Court says, all right, I did ask. Mr. Jackson says, great. Court says, and I know Miss Reed's family is behind you, so you don't see them, and you see the O'Keefe's family because they're next to you. There's music in the background. What was that? While we're here, oh, that's outside. I thought it was inside. While we're here, I just want to let you all know, says the court, and then redacted. I'll just tell the jurors. Mr. Unity says, of course, this is what the redaction looks like. The big C. Of course. All right. You all set? Mr. Unity says yes. Clerk calls the case. Okay, good morning again, counsel. Good morning again, Ms. Reed. Good morning, jurors. I have to ask you those same three questions. Were you able to follow the instructions and refrain from discussing this case with anyone since you left here on Friday? Everyone said yes or nodded affirmatively. Were you able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here on Friday afternoon? Everyone said no or shook their heads. Thank you very much. May we have Miss McCabe, please? And Jennifer McCabe's sworn. Court says, all right, Mr. Jackson, whenever you're ready. Mr. Jackson says, thank you, Your Honor. And then you get cross-examination. Let me see when the next sidebar happens. Let me search for sidebars. I was hoping this would work. Sidebar. Let's see, that was the first sidebar. And then that was the end of the sidebar. Next one, sidebar commences. So we want to see, the court says, I want to see the counsel at sidebar for just a minute. Let's go see what led to this, right? So we back up. We say, you're looking directly in my face, but you can see things that are between you and me because you have a field of vision, right? Mr. Lally says, objection. Who was this to? This is when she was looking right at you. If I'm looking straight out of an SUV and I'm not looking... Okay, the question was, no, of course not, because if you had a clear field of view to the SUV, you could see everything in front of it as well, meaning between you and the SUV as well, right? So we're talking about her looking out of the house at the SUV. And the answer is, if I'm looking straight out at an SUV, I'm not looking down at the ground. And the question, let me ask you a question about that. You're focusing right now on my face, yes? As you're answering these questions, you think, I thought we couldn't put in transcripts, but we did. You'd think you'd see, I don't know, an alligator sitting in front of me if it was there. He says, objection, Your Honor, sustained. Do you think you would see something? Can you clearly see there's nothing between you and me except a podium? Yes, well, there's a table. And you don't have to look down to see that, right? Correct. You're looking directly in my face, but you can see things that are between you and me because you have a field of vision, right? Mr. Lally objects. The court says, I want to see counsel at sidebar for just a minute. Jurors, feel free to stand and stretch. And then sidebar commences. Court says, what's the objection? Mr. Lyle says, as far as I don't understand the relevancy of what she can see in a lit courtroom versus what she can see when she's looking outside. Okay, so it's relevant, so I'm going to sustain that. Okay, so it's relevant, so I'm going to sustain that. Objection? But I don't like demonstrations without some heads up beforehand. Are you almost done with this? Mr. Jackson says, almost. The court says, it's argument, Mr. Jackson. Mr. Jackson, it's not, Your Honor. This is cross-examination. This is a huge point. The court says, what do you intend to do? Wow, these were spicy. Mr. Jackson says, I simply need to have an acknowledgement of her field of view is unobstructed, and using myself as an example is not argumentative. It's obvious. It's a point of cross-examination. Every single time I get into it with, and he's doing it for strategic purposes, I get it. But when I get into it with them, and I'm getting at making points, he stands up and objects and tries to undermine being discernible. And he's becoming obstructive and abusive. This is cross-examination. I should be given a little bit of leeway. Judge says, you've been given a lot of leeway. I called you over here because having said argumentative, whatever, he did not, but indiscernible. It is argumentative. Mr. Jackson says, yes, Your Honor. End of sidebar. May I proceed, Your Honor? Court says, yes. Oh, man. So now let's go to the next sidebar. That was the field of vision. We got that one. Next one. End of sidebar. Next start. This is Mr. Lally. Let's see. If you look where it indicates on the left column, I'm putting my thumb there. And the left column, MSISD users, the number that ends here. So they're identifying a phone. They get an answer to this question before we approach, said Mr. Jackson. I have no idea what we're approaching about. This document? Mr. Lally says, yes. Why don't we just go up there? Mr. Jackson says, sure. May I have that, please? I need to look at it. Sidebar commences. Court says, oh, excellent. Thank you. Can I give this back to the witness? Jackson says, that one's redacted. This is not. I'm going to give back one which I am marking for identification. The redacted one. Thank you. End of sidebar. Ms. McCabe, I'm going to give you that. You can something, and then another sidebar. The court says, okay, so do you have a copy, Mr. Lally? I do, not with me. Okay, all right. So my issue, Your Honor, is that they're shown it to the witness, asked her if she recognized it. She said no. And then reading from that, this isn't Mr. Lally complaining. She said no. So then reading from that document, what the document says when it hasn't been authenticated, I don't know what we're doing. Mr. Jackson says, well, I'll tell you what we're doing. This is a little bit of ridiculous ridiculous objection. Judge says, so those commentaries don't advance the ball. So just tell me what this is. Was this? Mr. Jackson says, it's her own extraction. Court says, okay. Mr. Jackson said, he showed her an authenticated John's extraction. Court says, okay. So Mr. Jackson, and I'm showing her her own extraction, which is going to be compared to John's extraction. And if we can do this the hard way, I can get it done, I think. The court says, so the ridiculous something doesn't advance the ball. If you had told me first that this is what I saw as an exhibit in the federal grand jury minutes, right, but I reviewed them yesterday. Mr. Jackson says, yes, Your Honor. The court says, okay, she doesn't have to authenticate this, right, but you're going to tell her that it's her phone number and point her to her phone number? Mr. Jackson says, I am. The court says, so my guess is she will. If she doesn't, you can object, and then we'll take it from there. Mr. Jackson says, so my anticipation was showing her the last 4 digits of her phone number, as it were, and I can use the unredacted. It's the last used something, that number, and then the Apple ID is going to be her as well. The court says, okay. Mr. Jackson says, I redacted the Apple ID just so I could enter it if I needed to, but I can ask the court to use her, the court's unredacted copy, just lay a foundation if need be. Ms. Little says, I have extra copies as well. Of course, Ms. Little has extra copies. The court, okay, all right, so I'm going to allow this and see where we get. Mr. Jackson says, okay, thank you. End of sidebar. And so they give her the unredacted version. Let's see, and then we get right here. Next one, next sidebar. Did anybody else go with you to Michael Lank's house? Answer, no. It was Carrie, myself, and her daughter. Your Honor, may we approach briefly? Okay, Sidebah commences. I'm going to move in a different subject. I was thinking this might be a good time as any to break. All right. How much longer do you think you'll have with her? Do you know what page number it is? Says Mr. Jackson. You probably have another hour, says Miss Little. I would think at least an hour. Court says, okay, who's tomorrow? Can you do 10 minutes? Jackson says, sure I can. Yeah, why don't we go right up to 1 o'clock? Jackson says, absolutely. Judge says, jurors, we're going to try to go right up till 1 o'clock, okay? By Mr. Jackson. Miss McCabe, we've talked in some detail about your calls with John O'Keefe in the morning of January 29th. Do you recall that conversation? Yes. So it continues on. That was just a lunch one. So now went to 1 o'clock and they've got a, I didn't realize they had this at the end. Look at this. They've got a table of contents. So you can look up where erratic appears. And disregard. And discord. Flagpole. This is cool. No wonder it costs so much to get one of these things done. This is a lot of work.
Squirrel.
Squirrels. Yeah, I'm sidetracked a little bit. Table of contents made RA happier than Christmas. It's like a Christmas gift to me. Get a table of contents. That's just cool. I mean, pick a word, any word. Sidebar. That's a good one. It's in there a lot. Woman, and then something's blocked out. What comes between woman and word? All the timestamps? Oh my goodness, look at that. This has got to be a program that does this. All the numbers. Covering up the 29th. Has a lot of times on it. That's just cool. This was the first trial. And how many times did Lally say snow? Let's look at snow and see if snow happened in this particular day. Would have been right here. So snow happened on this day. We had 1, 2, 3, 4, 5, 6 references to snow on the 11th or on the 21st. Do you think it will have words like if? Okay, I need to be able to scroll a little faster than that. H-I. Yeah, if is too small a word, I think. I'd. No if. No if. What about what if any? What's? See, any. Allie, analyzed, apologized. I'm sorry, I'm having too much fun. Check the DMs. Okay, let me look at DMs just 1 second. Am I supposed to check my DMs or? Okay, this is the next one. Let's close this one down for a minute and jump back to... All right, let's see what file we have. We're looking for the 22nd. May 22nd, 2024. It's 109 pages. A, because we have many parts of this one. Okay. Next one. I'm sorry, I got sidetracked on the index on the back, but we're here now. Next day, in court, what do we have? This is Jennifer McCabe, cross, redirect, recross. Are those minutes? I'm guessing minutes done on each one. Check group records, extraction report, and consent form. And we're going to go ahead and search for sidebar here as well. All right, here we go. Why don't we come over here for a while while we bring the jurors in and a sidebar commences. So beginning of the day. Court says, I'd really just like to get it moving if we can. So there's one issue. It'll be fine. Mr. Jackson says, super brief. The court has some impounded phone records that we've never been provided. Whoa. Court says, okay. Mr. Jackson says, I just want to go through about 12 or 13 calls that are only in those phone records. Clerk says, they're right there. Mr. Jackson says, that's it. So if you could just make those available to me and unimpound them for purposes.
I was told counsel wanted to see me at Sidebah.
For purposes of... Mr. Unity says, yeah, they're unimpounded with regard to the attorneys anyway. We'd like to make copies of those so that they'd potentially be highlighted or used. Mr. Jackson says, that's about, well, maybe a dozen calls in here that she's not going to know unless she is presented with the documents. So I just want permission to use these with her. Judge says, you can use these. Mr. Jackson says, okay, but it looks like, so let's mark these, please. The exhibit's marked for identification. The court says, all right. So you can use these original, but if you put it in evidence, do you intend to put something in evidence? Mr. Jackson says, no. Court says, I was going to say, it looks like there's a lot of redactions that need to be made. Mr. Jackson says, some were to refresh her recollection or see if she adopts them. Court says, okay, is there any objections? Only Mr. Jackson. Mr. Unetti says, I'm sorry. Lally, no. Court, okay. It would be a lot easier if they had permission to highlight, says Mr. Jackson, if I had permission to highlight. If you want me to ask Miss Little to make a copy real quick, we've got a copy machine right there. The court says, yeah, so we can't highlight. Okay, then while I start with the witness, she can just, if she has permission to leave counsel table and just make a quick copy. The court says, sure. And when you finish with this, so I noticed yesterday, I think you were asked for one of the exhibits before it was raised. I didn't have a problem with that, but the exhibits are to stay with the clerk. What am I hearing? Why is... Oh, Judge Simpson's court just started. I had audio running to that. I'll record it just for posterity's sake. Let's go back to where we were. All right. Understood. So this is for what has been marked 00 for identification, or 00. If you can make a copy, Miss Little, and you'll need both, correct? The unredacted, or you just, Miss Jackson says, no, I just need the copy. Court says, okay, so if you could give it back. Miss Little says, sure, to the clerk, no problem, I'm ready. The clerk calls the case, and we move forward with that document. Okay, that was the end of the sidebar. Let's see when the next one happens. What led us to this? Mr. Jackson is saying, document containing a printout of chat group marked Exhibit 98. Does it cover more than what we covered yesterday? This is the exact same document. I just failed to do it yesterday. My fault. All right. So is there still more? I'm just curious if my form is different than yours. Should be exactly the same, says Mr. Jackson. Why don't I take a look at the exhibit, please? Why don't you come to sidebar, please? Sidebar commences. Mr. Lally says, my apologies, Your Honor. I should say no objection other than the repeated objections that we made as far as. Perfect. Let's see, as far as, and the court says, yeah, so you're not waiving any objections that you made. So there were some that you didn't cover yesterday, and I'm just wondering if there's an objection from the Commonwealth. I checked off all the ones. Let me make this a little bigger. I checked off all the ones that you specifically went over with her, and there are others you didn't like that were beyond. I put them in groups, so not all of them were covered. But if there's not, that's why I was wondering if you're putting in the whole document, even though you didn't cover them. Mr. Jackson says, I am, because she indicated that all of it was correct, although I didn't highlight certain of them because they're quite frankly sort of irrelevant. Court says, okay. Mr. Jackson says, but I haven't. Something, jurors seen all of it because it's all part of the same. Court says, so that's why I just wanted to make sure we're all on the same page, because there were several that were violated. You were on the same page with, if it's coming in, all these come in? Mr. Lally says, sure. Court says, so I'll quickly just remind them the digital evidence instruction. Thank you. Thank you. End of sidebar. So far, I think the judge is being efficient in her time. She reads the instruction to the jurors, and they'll go on to the next sidebar. Maybe we approach briefly. I'd have to look at the call records. This is the answer. Do you believe that you had additional phone calls with Trooper Proctor after the last call on the 31st? I have to look at the call records. Sidebar commences. Jackson says, I did not realize this, but these calls end on February 1st. There should be additional call records, which I'm not going to worry about. It's too laborious. The court says, okay. Mr. Jackson says, they go through all of February, all of March. I'm just going to ask her about those. If she doesn't remember them, she doesn't remember them. But these are, I didn't realize these are not full panoply. This is a word I've never said before in my life. Panoply. Is it panoply? Of calls. The court probably has them, but these aren't hit. That's okay. That's what the court has. There's nothing else, Mr. Jackson says. As far as my recollection, that's what I received, so Mr. Lally. Ms. McLaughlin says, we have notes that we took from the ones that were in the court's possession that go months after this. Mr. Jackson says, so we have one of our associates come and look at the court file. He couldn't take them, but he actually scribed notes that go all the way through March, so I know they've been in the court file. Your Honor, I honestly don't want to, the court says, I'll ask Jim to go see if he can go find them. We're missing records. Mr. Jackson says, I mean, I would love that, but I don't want to bog this cross down any further. It is important. The court says, Jim. The clerk says, yes. The court says, it appears there's maybe additional impounded records. Could you go call down and see if there are, or go down and see if there are? Clerk says, there's about 700 impounded stuff. Court says, no, that came in with this. Clerk says, all right, that's the only thing that came in that. Court says, oh. Mr. Lally says, it would have been that same batch. They all came in that one. It should have been that one on both. Mr. Jackson says, it appears that they've been misplaced then. Oh, my goodness. Your Honor, with the court's permission, I'll just go ahead. Like I said, I don't want to bog down the cross. I'll go ahead and forge ahead. Court says, okay, so do whatever you want to do. But Mr. McDermott is leaving the courtroom now to go look. Mr. Jackson says, okay. Court says, all right, so I'll give you back this. End of sidebar. We're just missing 700 pages of redacted phone records. It's nothing to see here. Just continue as you were. That's wild. Okay, now we're going to say questions by Mr. Lally. What grade did you teach? 5th. How long did you teach 5th grade? Mr. Jackson says, objection. I'm going to see counsel at sidebar. I'm going to see counsel at sidebar. Folks, feel free to stand up. Sidebar commences. So why don't you tell me your objection, says the court. Mr. Jackson says, relevance. The court says, where are you going with this?
Counsel wanted to see me at sidebar.
Mr. Lally says, it's going to be a fact that she has no familiarity whatsoever with Celebrite, phone extractions, or anything of the like. She's had no prior experience with personally, professionally, or anything else. The court says, I'm not sure that's the way to do it. Mr. Jackson says, I don't think it is either. He's trying to humanize her and make her this little school teacher. It's completely irrelevant. Court says, so you can do that other ways, but not that she was an elementary school teacher. Mr. Lally says, okay, end of sidebar. If I could take you back to around 4:53 in the morning is when you get that first call from blank. Is that correct? Correct. Right. Speak up, Mr. Lally. Let's see. Another sidebar. And more to my point, this is Mr. Lally saying, you heard the defendant make a variety of statements over the course of the morning, correct? Yes. And more to my point, as far as you recall testifying at another hearing under oath in June of 2023, correct? That would be the grand jury. Yes. Do you recall being asked some questions initially about this topic? Mr. Jackson says objection. The court says allowed. Jackson says sidebar. Court says okay. Sidebar commences. What's the objection, Mr. Jackson? Mr. Jackson says it's hearsay. I expect that Mr. Lally will say it's prior inconsistent statement, but it's not because it postdates the original statements. It's not prior to the statement that she was impeached significantly on. So he does not have the right to get into a consistent statement in June of 2023 when all her inconsistent statements were in January, February, and April of 2022. The court says, all right, you mentioned yesterday about her testifying yesterday. Mr. Jackson says, I don't think I mentioned I could be wrong because it was lengthy, but I don't. The court says, Mr. Lally, what do you say? I'll look for it, Mr. Jackson, if I recall. Mr. Jackson says, it could be my failing memory and age. I don't remember bringing up the June hearing back then on the issue of whatever. Mr. Lally says, on that specific issue, no. But when it comes to the prior inconsistent statements, counsel wanted to introduce prior inconsistent statements. I'm then allowed to rehabilitate the prior inconsistent statements, especially sworn ones, under oath. Mr. Jackson says, a prior inconsistent statement has to predate the inconsistent statements. Court says, so what I was looking for yesterday, you mentioned it. Now she's bringing it up today, so prior consistent would be prior to yesterday. I'm just trying to find that testimony. If the Commonwealth doesn't have it, I'm not going to. If it's only prior consistent as to yesterday and you're challenging her on, Mr. Jackson says, correct. The court says, yesterday. Mr. Jackson says, what she said Friday, exactly. So impeach her with that, what she previously said to that. The court says, no, I understand. But I thought there was some recent fabrication on Friday which would give prior to Friday as a prior consistent statement. Mr. Jackson says, I believe that the prior consistent statement has to predate the inconsistent statements. In other words, we start with the foundation of the statement. Judge says, and ordinarily it would be except for you made it sound like indiscernible. Mr. Jackson says, I didn't. I just said I was very careful not to say you never brought it up before. I just said on Friday, you said X, but previous to this, you said Y. Mr. Lally says, and that's what I believed happened as far as there was a specific question about whether you said anything under oath or anywhere before these statements that you said were on the stand the other day. Mr. Jackson says, that's absolutely not true. I wouldn't do that. That would be malpractice if I did that. I would never say that because I know that she did say that. The court says, unethical is different than malpractice. Mr. Jackson says, I wouldn't do that. The court says, one is much greater than the other. Mr. Jackson says, understood. No, I did not and would not do that. I would not make a knowingly false statement that she didn't blank. I was careful to move around that. The court says, what's the statement you intend to put in, Mr. Lally? Lally says, her statement that's entirely consistent with what her testimony was. The court says, what is the specific statement? Mr. Lally says, the specific statement is, so there's two different portions within the federal grand jury testimony. It's on page 816. The court said, it's on what page? 816 is the first one, says Lally. End of sidebar. Then it continues. All right. I don't know why they do this. Oh, the court turned to the jurors and said, jurors, feel free to stand and stretch. And then they continue the sidebar. All right, where is this? Right at the bottom of the page, says Mr. Lally. Court says, Mr. Jackson, I'm going to let this in subject to, I will strike it if it's not, but my memory was that the way it was built up about Friday being a recent fabrication. Mr. Jackson says, okay, I understand. Court says, we'll have time and we can go through, I'll strike it. Mr. Jackson says, understood. The court says, however you want me to strike it. Mr. Jackson says, understood, thank you. End of sidebar. And then Lally proceeds. Hey, little miss, I need to see what's behind your head. Okay, thanks. Next sidebar. Let's see, this is... You were asked a second ago by Mr. Lally if Karen Reed hadn't jumped out of the car, you wouldn't have stopped, correct? She says, correct. Mr. Jackson says, thank you, that's all I have. Court says, okay, all right, Miss McCabe, we are finished. Jurors, I'm going to ask you to follow them out. Witness says, okay. The court says, like you've done, we'll take a recess. This one might feel a little longer. Court officer says, jurors, folding and leaving your notebooks on the chairs, all rise, follow me, jury out. The jury leaves. The court says, in an effort to save a little time, why don't I see you at sidebar? It's just easier to start from here. It saves us a little bit. So what am I doing? What are you requesting? Ms. Giannetti says, so 3. Court says, who's your next witness? Miss Roberts. Right, says Giannetti.
I was told counsel wanted to see me at sidebar.
It doesn't apply to Carrie Roberts. Who's getting these sidebar things in? Baby Shark, that's awesome. It doesn't apply to Carrie Roberts. 3 issues. One is we want to renew our objection to providing impeachment material to the prosecution in advance of their witness testifying. The court says, what was that? I don't know what you're talking about. Mr. Giannetti says, so this court entered a discovery order indicating that we had to identify the documents and other things that we would be using as exhibits to impeach witnesses. As I said, when the court issued the order, the court has the discretion to do that, but we're renewing our objection in light of the fact that the material that we provided to the Commonwealth regarding this unreported on meeting at the lengths, how Karen was communicated to Jennifer McCabe so that they could then anticipate and prepare for that cross when they shouldn't be allowed to do that. That's number 1. The court said, that was a total surprise to me yesterday. I had no idea that had taken place. Mr. Giannetti said, it was a surprise to us. I had no idea that occurred, so your objection is noted. Mr. Jackson says, and just so the court knows, we have done extensive work on the forensic download, and we found that GPS coordinates, so we discovered it. She had never told it to Mr. Lally. She had never told it to the police. It was a complete surprise. It was perfect impeachment, and we lost that moment because Mr. Lally took it and presented it to the witness, and then she had an excuse. So the testimony got out, but it was a little disconcerting that our hard work and our impeachment, which was pure impeachment, was being presented in meetings that we had no idea about, and then she gave statements that were not then discovered to us. So I wasn't flat-footed, but I was close to it. The court says, okay, that objection is noted. Ms. Giannetti goes on, a related objection is the fact that there was apparently a meeting that took place where she revealed new information where Lieutenant Tully was there along with the DA's office, and that was not disclosed to us until she was on the stand yesterday. Our view is that any new statements are inconsistent with her previous statement. The court says, okay, this should be Mr. Jackson's argument. It was your witness. Mr. Jackson says, I'll let go what he just said. The court says, okay. Mr. Jackson says, any new statements, especially as it pertains to Ms. McCabe or any witness going forward, if there are interviews, they may call them prep sessions. If there are interviews or prep sessions that reveal new information or new dialogue between and among witnesses, we should have them. We should have that. We should have a report of every one of them. The court says, that's concerning. What happened, Mr. Lally? Mr. Lally says, on that, so what we've been doing consistently throughout, and that's part of the reason I have Lieutenant Tully with me and I meet when I meet with any witnesses, is any change or new information or anything like that has been reduced to writing and provided to counsel as soon as I have it. This I wasn't aware of. Mr. Jackson says, that's what I don't understand. When I confronted the witness, she said Mr. Lally had got it to them. Well, that doesn't absolve him of the responsibility that Sergeant Tully has to reduce it to writing and present it with. Mr. Lally says, to be clear, that was a meeting that occurred while we were on trial. So that was, and I think she was clear on that. Initially, I think she was confused, but I think she clarified as far as there were 2 separate. There was one meeting where, yes, I was there. This other meeting, she had asked to go to re-review her grand jury testimony on day that we were on trial, and I asked Lieutenant Tully to sort of monitor that. Court says, all right. And you said that there was new information that resulted from that or from the meeting itself was new? Mr. Jackson says both. We didn't know about the meeting and the new information that was Lieutenant Tully was provided and clearly provided information about impeachment and confronted her with it. He said, what are you doing at Mike's house on the 30th? And she said, I met with his wife. Lieutenant Tully didn't ask any follow-up. If you recall that dialogue, and that's just unfathomable, I know Lieutenant Tully well enough. I'd have read 1,000 reports. He could have followed up. So he'll be on the stand, and you'll get to cross-examine him with plenty of notice, the court says. Jackson says, right. All right, says Canoni. What's your other point? Mr. Unetti says, and the only other issue is we do expect that after Miss Roberts, that the Commonwealth will be calling the Sullivan sisters about the Aruba trip. And our view on that is that the evidence is inadmissible. That is bad character evidence, and we're requesting a voir dire prior to their testimony to parse out what they can testify to and what they can't. The court says, all right, who's doing that cross? Mr. Unetti says, I am. All right, so you objected to it before. I said that it's coming in. You got the grand jury minutes from them. You can object on a question-by-question basis, but it comes in as, and I will certainly give a prior bad acts instruction, and it goes to the nature of the relationship, potential motive. I made all those findings. Court comes back on the record. I made all those findings. We're on the record, by the way. All right, so based on my reading of the grand jury minutes, and of course I will do this, it's awkward to make these findings under the footnote 8 of Commonwealth versus Semia that I have to make, so it's better to do them now. Not sure what she's talking about here. Guys, this is a ton. Lally was smarter than he led us to believe. I always felt Lally was so incompetent, but proactively malingering in the case. Lally knew. I call BS. Yeah. Drama Mama says, legal question here. If anything comes out of these transcripts that's not legally good, can the wrong person get into trouble? The transcript is the record, and typically at this point it would be the record for an appeal. So if a side has appellate rights or options, that would be pretty much the limit of it. There's a possibility the transcript could document a major misstep by a lawyer, which could personally have ramifications in their professional life, being censured, sanctioned, or stripped of their bar card. They're all options that can come from behaving inappropriately as an officer of the court. But I don't think that if something like that happened, it already happened, and the occurrence of it in court was the problem. The document would just support it. I don't think anyone's going to pour through these and say, oh my goodness, look, they did something wrong because of this, except for the defense. If they are appealing any conviction, they could use sidebar decisions by the judge and things like that to argue an appeal. It loses some of the meaning without the Boston accent. Jackson got cut off, and you could see he lost his wind. Now we know why.
I was told counsel wanted to see me at Sidebah.
You guys, this is exhausting. I don't know how long we've been reading. It feels like 2 hours. It's been 49 minutes. It's probably only been half an hour. Amber, are all these up on... It's been 40 minutes. This is exhausting. Are all these up on Discord? 84 years later. This would be good stuff to read. I tried to dump it into AI just to have it extract stuff, and it doesn't handle this very well. It failed every time I tried. Let's see. Let's go to the next one. I think we're almost done with this one. Sidebar. This word only occurs once. I don't remember all these words coming in ever. Like, did we watch the same trial? We've got shock. And where's horror? Shock and horror. Horrific, horrified, and horrifying, but that's all. All right. I don't know. Maybe I just ate too much for lunch. I'm just getting like a wave of exhaustion. At least there's no headache with it. And there's copyright as well. Or something between believed and benefits. Like, I guess Belinda would fit in there if there's a Belinda. Look at all the references to Haas. Okay. Just today. There's a few. Haas long. Haas long. Some good words in here. I'm looking for nice words to add to my vocabulary. The Penelope or whatever it was. Where was that word? See if I can find it again. And it's gone. There was a good word there, but what was the word again? Panoply? Panoply. All right, here. What does it mean? Panoply? Panoply, not... Panoply. 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 Yeah, I was saying like monopoly, which would have an O right here between the P and the L. So, panoply. What does it mean? It means the entire thing. It's word of the day. There's a test at the end of the day, by the way. Ozone. Ozone was mentioned? You got there. They, they'd, they've. All right. What are we doing? I was getting lost in a dictionary. Do we have all the new trials transcripts? No. This is just the first batch, trial number 1. I don't think the second ones have been released yet. It normally takes like 6 months to get something like this done, to get it transcribed fully and official, and it costs a ton. Like I would not be surprised if somebody spent over $50,000 getting this transcribed. DSN, happy holiday and Merry Christmas. Thank you very much, DSN. Same to you as well. We are just a couple days away from Christmas here in the U.S. I know some of you in other parts of the world, Christmas is tomorrow. Don't spoil it for us. Don't tell us what we're getting just because you find out early. But Blue Paint was trial 2. That would be a blast. Sidebar. It's the 24th here. I try to explain that to my daughter. She would be a little confused. Dates are hard for her. She does amazingly with it, but she says, when I count how far away Christmas is, I count the number of days, but then it always seems to take longer than that. So I count the number of days and then I add one. Because in her mind, just the days take forever when you're waiting. But it's funny. Trooper Paul was trial number 1. What day was he there? Does anybody know, like, the date? Because we could jump back and take a quick look. Where would Trooper Paul be? Your options are starting at 429 up through 522. Let's see. Let me ask Rock. Okay. Multiple days in June. Friday, June 14th. That would be this one. And he continued Monday, June 17th. So we want probably the cross-examination. Right? Tell you, if you have not used AI to do research yet, you're missing out. Imagine Googling everything on the internet all at once. That's what AI can do for you. If you learn a little bit about how to use it, it is absolutely fantastic. Now it doesn't. Where it fails is when there's bad information out there, because it will return the bad information as information. But if you've got something like this, historical, it's amazing. So, like my little search where I asked, what date did Trooper Paul testify in Karen Read's first trial? And it replied, after searching 48 web pages, and it gave this answer. Trooper Joseph Paul, Massachusetts State Police crash reconstruction expert, often referred to as Trooper Joe Paul or Trooper Paul, testified in Karen Read's first murder trial, which ran from April to July 2024 and ended in a mistrial. His testimony spanned multiple days in June 2024. He began testifying Friday, June 14th, presenting data from Read's Lexus SUV, details on vehicle testing, speed, braking, backup camera, and conclusions that O'Keefe's injuries were consistent with the pedestrian strike by the vehicle. He continued and faced cross-examination on Monday, June 17th, where the defense challenged his credentials, data interpretations, and reconstruction methods. No Massachusetts state trooper named simply Paul, without Joseph, testified in the case. The lead investigator was Trooper Michael Proctor, who testified starting June 10th. Trooper Paul also testified in the 2025 retrial, but the question specifies the first trial. So that's just pretty cool that it can do that. Trooper Paul. Let's see what happens here. Let's see, we have... Is this the right day? Counsel come to sidebar. Good morning, Your Honor. Good morning. Good morning, Judge. You have to stop being late, really. Mr. Jackson says, I just want to put very briefly on the record. Why don't you step aside? Mr. Unetti says, of course. Yes. But Jackson said, I just wanted to put very briefly on the record with regard to Miss Kuhn. We want to interpose an objection for just for the record in terms of her testifying before the foundation has been properly laid. I sort of expected it. I knew she was going to be taken out of order. Mr. Lally let us know that. But I expected, the court said, because of a blank. Is that what it is? Mr. Lally says, yes. Mr. Jackson says, I have no problem with that whatsoever. I just want to make sure that I didn't waive any objection in the latter foundation of her testimony is not established. I think it will be. Court says, if it's not established, move to strike it. Mr. Jackson says, okay, that's what I wanted to make sure of. That's all. Thank you. The court says, okay. Ms. McLaughlin says, while we're here, one more thing, Your Honor. Court says, sure, of course. Move aside, Mr. Lally. There's so little room there. They have to play rotate positions so the judge can hear. Based on the court's order yesterday, the Commonwealth did review the professional rules of code of conduct. The court says, okay. And she says, the Commonwealth did not find any rule that pertains to the situation or the issue the defense or counsel raised. The closest thing would have been professional rule of conduct, 3.4a, discussing an attorney's duty not to obstruct evidence. That's not what the Commonwealth did or intended to do, and there's no cases citing that rule for any proposition or supposed issue raised by the defense. However, given the court's broad discretion by the Commonwealth, myself and Ayden Lally will abide by the court's order as it likely falls within the judge's broad discretion pursuant to Criminal Procedure Rule 21 and sequestration. So myself and Ayden Lally will abide by the court order, and I presume defense counsel will as well. Court says, okay, unlike all of you, I have never been a prosecutor. Surprise? All right. Are you still moving for that, Mr. Jackson says, yes, Your Honor, we are. Anybody from the Commonwealth's team, they're investigators, they're victim advocates, the trial team themselves, nobody from the Commonwealth, just like nobody from the defense. They're victim advocates, the trial team themselves, nobody from the Commonwealth, just like nobody from the defense, should be engaging a witness who is currently under oath during the breaks, overnight and the things of that nature. It's just not done. Court says, I think investigators is a little too broad. Police are not allowed to talk to witnesses. Mr. Jackson says, not while they're on the stand, not while they're under oath. Court says, what do you say? Ms. McLaughlin says, there's no rule that suggests that. If that's the court's order, the Commonwealth should abide by it. However, I feel if a victim witness advocate need to be able to speak to the witnesses, as it came up in this case, our witness was confronted about a conversation they had with a member of the Commonwealth team, and their answer was they asked me if I wanted any water. So I think effectively, move the trial forward. Advocates or witness people need to be able to speak, need to be able to ask people, do they know where the bathroom is, or are you going to be up next in 5 minutes? Just normal ability to facilitate the time management of the trial. Mr. Jackson says, to be clear, that's not what I'm objecting to. I'm objecting to any interviews or discussion of the substance of their testimony, asking where the bathroom is, what time do you need to be here, can I have some water? I have no problem with that. The court says, how long is your testimony going to be? Mr. Jackson says, correct. I mean, you're going to be another hour. I have no problem with that. I just don't think it's appropriate to talk to them about, I'm going to ask you these questions. I expect Mr. Jackson. The court says, yes, I don't think that's proper either. I may be wrong, but I do know sometimes things come up during trial that a police officer has to go out and find a witness or approach a witness or something based on something that's been said. So I don't want to tie the strings of the law enforcement. I was concerned you raised it regarding the lawyer, Mr. Lally, and that's what I addressed. Mr. Jackson says, right. Court says, so Mr. Lally, you're not to flag the witness that you're going to examine them on or redirect on any other substance of what you're going to do. Mr. Lally says, understood, Your Honor. Just so the record is clear, that is not what happened in this particular case. I went to tell the witness, this one being Mr. Albert, how much I anticipated he would be left on the stand. He asked me a question as far as, are you going to cover this in your direct? And I said, yes. There was no substantive conversation about, I'm going to ask you this, or Mr. Jackson may ask you that, or anything along the lines. But whatever the court's ruling is, obviously the Commonwealth will abide by whatever the court tells us to do. The court says, my understanding has always been a witness is on the stand. You can't discuss anything of the substance with that witness. Mr. Lally says, I understand. The court says, and that's what I've always thought, and that's what I believe. We will leave it at that. Mr. McLaughlin says, thank you. Mr. Jackson says, thank you, whereupon the sidebar is concluded. And the court says, bring the jurors. Wow. Good stuff. Good stuff. Oh, my goodness. The nightmare trial that never ends. The sidebars are crazy. I will say the judge is pretty consistent in them, but we don't get the tone is what we don't get, which I wish we had. I wish we had the audio recording or the video even, so we get facial expressions. All right, guys. I'm sorry. It is 2:00. Let me check and see if we have anybody that we can court hop to before we wrap things up for the day. Judge Simpson's live. What's he doing?
Go ahead, sir. Good afternoon, Your Honor. We're asking for a competency hearing. It should not be too long.
And you have?
I'll stipulate to the curriculum vitae that was given to me about a half hour ago.
Well, let me try to understand. This is the...
May we approach?
Well,
be helpful
in a moment, but...
What day was that?
The drafter of the report is present?
Yes, sir.
Is this who's in Zoom or?
Yes, it's Ms. Jayasuri.
Got it. Okay. All right. You may approach.
I'm checking to see when the inverted video was. Paul Mack, it's 1 p.m. where you are. I'm getting 2 p.m. East Coast. Let's see. The defense first raised the issue of inverted mirrored Sally Port video during the cross-examination of Trooper Buchanan. Trying to get the date. June 6th. I don't have a June 6th. Why is there not a 6th? Did I miss it? Let's try the 7th. Okay, we'll come back. Well, he's still at Sidebar. Sorry, ma'am. We're bailing on you. We're going to search for inverted. Nope. Maybe on the right keyboard. Not seeing it. Let's see. It's not there. Why is that day missing? Has that whole day been redacted? Original 5th June, cross of the 6th, I believe. In the document dump that I got, we got the 4th, and then it goes to the 7th. So the 5th and the 6th are not here. I'm sorry. All right. they're missing. They're gone.
If you could just use your words.
All right. I don't know why, but I'm literally about to fall asleep as I sit here, and I got plenty of sleep last night. So, presented with the option of either snoring on camera and having it clipped and living forever in infamy on the internet, and taking an early day prior to Christmas. I'm going to go with taking an early day prior to Christmas. So we're going to wrap up here. Let me tell you that I would ask that if you have not already, please submit. JMR's like, please give me the video. Please submit a picture of your Christmas tree. Tomorrow we're going to do a large version of show and tell where we're going to compare and ooh and ah over everyone's trees. And at the end of that, I will show you my tree. Every picture I have gotten of every tree, whether it be 2 foot tall or 20 foot tall, we've got, I think, everything in the middle. Your trees look better than mine. I mean, like, they look more professionally well decorated, balanced, the feng shui, everything else. Mine is very unique. And it also has a funny curve in the top portion because it was just bent in the box and they just stuck it on the top of the tree like that. And that's the way it is. Where do we send the photo? You can either, if you're here in the US, you can text it to the burner phone, right? The burner phone is accepting text images of trees. I am not saving your name or your pet's name if the pet's in front of the tree or playing with the tree or something like that. I'm just grabbing the pictures. So when we do the presentation, you'll have to be here and say, hey, that's my living room, or that's my tree, or that's whatever. So I'm stopping screen recording. Gotcha. Send it to the burner phone. If the burner phone is not an option for you, like it costs money or you're overseas or something like that, or you don't have a phone, on the Facebook page, which is free to join and free to be a member of as long as you answer the questions, you can submit it. There's a link there, and you can do it that way. If you sent yours on Discord, it won't get to me. Purple coconut. I just don't check Discord. I'll need Amber to forward everything. So the burner phone is accepting pictures of your tree. It's a fun Mad Lib. Yes, tree is the correct word. It's the only word that goes in that spot. All right. Tree only. We're not. All the pictures will be screened prior to being exhibited. People who break the rules egregiously will be blocked. Too many turtles. It might have been. Man. Do have some shrubberies out there. We've got some shrubbery. Red Pen, good luck with the lasagna. Thank you, everyone. Thanks to our mods who are absolutely amazing. Thank you for sticking around while we read some of the interesting sidebars that took place in Karen Reed trial number 1. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe. Until we go live again tomorrow morning. Tomorrow is New Year's Eve, which makes this New Year's Adam right now. So we'll get some rest. How a tree from the Toledo Zoo? It's got to be your tree. It's got to be your tree. Tomorrow's Christmas Eve. Sorry. It's not quite New Year's Eve. I'm sorry. This is how tired I am. I just completely skipped over Festivus and the end of year celebration and everything. Christmas Eve tomorrow. You guys did not sleep through Christmas. The big day is still coming. We'll be here tomorrow morning. It's going to be a different show, more like a podcast than the traditional show, because nothing is happening in the world of true crime on Christmas Eve. Period. And I stand by that. So, you guys have a good night. We will see you in the morning. Your tree sucks. It just has personality. That's all. Send a picture. We'll judge it. We'll rank it on a scale of 1 to 10. I'm sure everyone will understand. You guys have a good one. We'll see you tomorrow morning. Bye-bye.